Um, so good afternoon, everyone. Thank you for joining in on this snowy day. I hope everyone is staying warm. My name is Rachel Mills. I work with the Louisiana State Bar Association, and we welcome you to our Law Talks virtual workshop series today. Today's Law Talk is on heirs property, and we have Jonathan Reynolds with Louisiana Appleseed presenting on this important topic. Let me go ahead and share my screen as well. 1 second. All right, Jonathan, can you see my screen?
Yeah, I can see it.
Perfect. So again, we're here to talk about heirs property today with Jonathan Reynolds. Before getting started, I need to go over a few important reminders. First, this presentation is being live streamed. Questions will be taken at the end, if time permits, and answered live. If you're watching at a library, you may ask or submit your question to the library staff. If you're watching via Zoom, please submit questions in the Q&A section. If you're watching via Facebook, please submit questions in the comments section. Please note that the comments are public and accessible by anyone during and after the presentation is over. Please note that the information provided on this presentation does not and is not intended to constitute legal advice. Instead, all information, content, and materials are for general informational purposes only. No viewer of this video should act or refrain from acting based on information provided in this presentation without first seeking legal advice from counsel in the relevant jurisdiction. If you need assistance finding legal help in Louisiana, please go to the LSBA's Find Legal Help page. The LSBA's inclusion of a program is not to be deemed a statement or an endorsement of the views expressed therein by the LSBA or any member of the LSBA. Speakers on LSBA programs were carefully selected for their knowledge, but neither the LSBA nor the speaker warrant that the presentations or materials were free of errors or will continue to be accurate. Statements in the presentation and their materials should be verified before relying on them. Opinions expressed are those of the speakers and do not necessarily reflect opinions of the LSBA, its section, or committees. Views expressed are those of the authors and contributors only. So our first presenter today is Jonathan Reynolds, the heirs property staff attorney with Louisiana Appleseed. Louisiana Appleseed is a great nonprofit that solves the state's toughest problems at their root cause by advocating for access to justice, opportunity, and education. Jonathan is currently a staff attorney for Louisiana Appleseed. He earned a Bachelor of Arts degree from the University of New Orleans and a law degree from Loyola College of Law. He began his career as a title examiner and abstractor for right-of-way and oil and gas projects. At this point, Jonathan, I'm going to turn it over to you.
All right. Good morning, everyone. My name is Jonathan Reynolds. I'm the heirs property staff attorney at Louisiana Appleseed. Really glad that everybody was able to join me here on this snowy day. We're going to walk through some of the basics of heirs property. Can we get the next slide, please? So heirs property is a term that is starting to become more and more relevant in the, I guess you'd say, the zeitgeist, the popular vernacular of the world right now. And so I wonder if everybody wonders, what is heirs property? We hear this term, we're starting to hear this term more and more. It's even starting to end up on television, in the news, things like that. So basically, heirs property is a movable property that's going to be land or houses or buildings. That's what we mean when we say a movable property that's owned in division. In division means you and a bunch of your co-owners who are related to each other all own this property together in equal parts and equal percentages. And it normally happens when maybe your parents owned a house, your grandparents owned a house, and now they die. Now you and all of your cousins and you and all of your siblings, you guys all own this house together. You own this immovable together in division. And now that's what would be called heirs property. Normally what happens in this situation, maybe your family didn't go through the proper formalities to get the property retitled into the new owner's names. And so as far as the city is concerned, as far as the parish is concerned, as far as the state is concerned, your grandmother or your parents still own the house. It's still in their name. It's not in you and your siblings' names. And there are a lot of issues that can come with that, owning property as heirs property. and we're going to go through some of the issues, but let's lay a little bit of the groundwork first. Next slide. Intestate succession order. Intestate succession order, that would be what happens when a person dies without a will. That's what happens when a person dies intestate, without a testament. That's what that word means when you hear that, intestate. We have a set of rules for where your property goes should you die intestate. And I think for the most part, the basic rules in Louisiana kind of follow what we believe in our soul and our hearts and our brains, what we think should happen. Like, think about, where do you think most people would want their property to go should they pass? Okay, the state of Louisiana says, should a person pass and they don't have a will, their property goes to their descendants. Your descendants would be your children or your children's children should one of your children have predeceased you. I believe that most people would agree that that's how most people want their property to go. What if the person never had descendants? What if they don't have any children or grandchildren? That's when it might go to your parents and your siblings. What if a person didn't have parents and siblings? That's when it goes to your surviving spouse. What if a person didn't have any of these things? That's when it goes up to your grandparents, things like that. And then if you don't have grandparents, that's when we get into like what we would call a Brewster's Millions type situation, where your third cousin removed or somebody might receive it. The actual order is not necessarily completely important to remember the order, besides the fact that descendants are the first people to take should you pass. It is important to know that your property doesn't just go into the ether or go to the state or go into non-ownership should you not have a will. I do recommend that everybody at least consider having a will, but this is to just reassure you that there are a set of rules for where your property is going to go. And for the most part, this set of rules follows the logic that most of us believe should happen. Next slide, please. What is a will? A will is going to be a document that's going to say where I want my property to go should I pass. Where do I want my things to go should I, and it's in a manner where it doesn't have to follow the default rules. A lot of people's wills actually do follow the default rules, and there are reasons why you might still want to have a will, even if you want your property to follow the default rules. There are actually two types of wills in the state of Louisiana, right? There's what we think of when we think of the typical will, a notarial will. That's where you go to the lawyer, you go to the notary, you have two witnesses, you sign and date it on each page, it's all typed up, you sign and date it on each page. That's a notarial will. One of the things I like to focus on here is the idea of an holographic will, or some people pronounce it a holographic will. That is a handwritten will, completely written in the testator's handwriting, in their own handwriting, signed and dated each page. That is actually valid in the state of Louisiana, to handwrite your own will. One of the issues that comes up when people try to do the holographic will is I've seen instances where maybe somebody printed the will from the internet and then they tried to write on it. That's not going to be sufficient for an holographic will. If it's not all in your own handwriting, then it's not going to be an holographic will. So the main reason I like to bring this up to people is the idea that you can have a handwritten will in the state of Louisiana if you follow the proper formalities. I do recommend that people not necessarily rely on an holographic will, but it is a great exercise to start thinking, when I do go to the lawyer, when I do go to the notary, what do I want my will to look like? How do I want things to be disseminated throughout my family? How do I want these things to happen? And it gets you thinking, and it's going to make it a lot easier when you're actually dealing with the lawyer to actually draft your will. It's going to make things a lot easier, right? One of the things that people ask is, well, why not just have an holographic will and rely on that? I have received holographic wills from people and then translated those wills into testamentary wills, notarial wills. One of the common things I see is I understand what the person wants their property to do, but the way that they have it written out, it's not actually going to legally work out like that. So I do recommend, after you have your holographic will, that you check it out and you have a notarial will done with a lawyer. One of the major things that I like to counsel people on when they have their notarial will done is make sure it's signed and dated on each page. Do that. Typically lawyers and notaries are very good about the other formalities of it, but you do have to be somewhat aware of certain things. So hopefully that gives you guys knowledge about the two different types of wills. One other thing that I need to point out with the concept of notarial wills is throughout my travels throughout Louisiana, a common thing that I've heard said is sometimes people might say, my grandfather doesn't speak English, he can't have a will. Or maybe my grandfather is blind, he can't have a will. Or maybe my grandfather is illiterate, he can't have a will. None of these things are true in the state of Louisiana. People who are blind can have wills. People who do not speak English can have wills. People who can't physically sign for themselves can have wills. The bar for having a will is, are you mentally cognizant and can you communicate this to other people, your wishes? It's going to take a lot of extra formality, but I don't want people to feel that their neighbors are not able to have wills because they're blind or illiterate or something along those lines. So just wanted to point that out. Can we get to the next slide, please? This is a simple family tree. We're going to try and point out some of the issues that come up in an heirs property type situation. Some of these things we're going to go into in a little bit more detail, but let's look at this family tree. We're going to assume that Alex and Martha, maybe they bought a house in, I don't know, maybe they bought a house in New Orleans in 1950. All the people in gray are now deceased in 2025. All the people in green are still alive. At one point, Alex and Martha, they passed. They did not have a will. When they passed, at this moment, Belinda and Bessie both own 50% of this house. Not necessarily a problem because in this instance, we're going to assume that Bessie lives in the house. Belinda moved to DC for college. So it's no big deal. Belinda comes back and visits Bessie every once in a while. That's one generation. 2 generations in, Bessie's deceased, Belinda's deceased. Now Jarrett lives in the house. That's why we have an asterisk by his name. Jarrett lives in this house. His niece and nephew, Tina and Tony, maybe they come and visit him on holidays. Maybe they come and visit and stay with him in the summer. Jules, she sees him for holidays. His cousin Jock, who grew up in DC, he sees Jock for family reunions. His cousins Sally and Saul, he sees them every once in a while. He's aware of them. His more removed cousins, Yvonne and Ignatius, he may have never even met them before. He might not even know that they exist. But once again, Jarrett lives on this property. He takes care of the property. He pays the property taxes on this property. A common question people have is they'll say, well, Jarrett owns it. Jarrett does not own this property. Jarrett owns this property in division with his cousins and his nieces and his niece and his nephew. And there are a lot of issues that can come up with Jarrett owning this property in this way. One of the questions that people bring up is, well, if he takes care of it, does that mean that his ownership supersedes their ownership? We're going to go on this one a little bit later, I believe. But no, in the state of Louisiana, any act of ownership that he takes on behalf of this property, it's presumed that he's taking this act of ownership on behalf of all of his co-owners, of everybody he owns it in division with. And one of the major issues that could come up when Jarrett owns the property like this is he doesn't have sole enjoyment of this property anymore. Even though right now in the family, it's a sort of an unspoken agreement that Jarrett has sole enjoyment of his property. That's not necessarily how things are going to shake out should someone want to move in with him. He's going to have great trouble preventing his relatives from doing this. So one of the things that we want to avoid is when Jarrett owns property like this, he's disincentivized from taking care of the property, knowing that any of his relatives can come in and force and also share enjoyment with the property with him like that. And we'd like to avoid this if we can. And I understand that it's difficult when you have limited resources, multiple children. It's difficult to actually figure out the best way to settle these issues. We're going to get into some of the ways that people have figured out on how to settle these issues. But just to point out how big of an issue that this is. And notice, I'm saying that this is from 1950 through 2025. So 75 years. Normally in 75 years, it's many more people involved in this than 1, 2, 3, 4, 5, 6, 7, 8, 9. I'd say normally around this time, it could be 40 people involved with this. And it's difficult for 2 people to share a house. It's definitely difficult for 40 people to share a house. In instances where it might be rural property, it might be more readily fixable issue. We'll get into that a little bit later. Next slide, please. One of the reasons I like to show this slide is the information we have on the left is a breakdown of percentages of ownership of current ownership of the property, and to show that it can be written as simple as this. But then I also like to compare it to the British royal family. That's what we have on the right. That's a family tree of the British royal family, and the idea that this family, they're a very wealthy, prestigious family, but they've figured it out already where everything's going to go, who's going to get what in this scenario, who's going to get this in this scenario. And now us, families of more moderate means, we also have these tools that we can use to preserve wealth in our own families. Next slide, please. A great question that always comes up is we hear the term succession, we hear the term probate, and people ask, what's the difference between succession and probate? And I'd like to tell people the difference between succession and probate is, where did your lawyer go to law school? In Louisiana, we call it succession. The rest of the United States, it's called probate. They're functionally interchangeable terms. There are some edge cases where they're not interchangeable, but normally when you're talking with your lawyer or your notary and you hear the word succession and you hear the words probate, let's, for the most part, consider these things analogous. Let's consider these things just one and the same. Well, what happens at a succession? What happens at a probate? That's going to be where your family, they go in front of a judge. If you have a will, they bring the will. If you don't have a will, they're open and intestate. They go before a judge, and the judge is going to look at an accounting of all your assets and debts. There's going to be a court proceeding. The judge is going to make an order. He's going to have a judgment of possession, and your family is going to be able to use that judgment of possession to actually change the title of different property that you own into the current owner's names, right? They're going to be able to take this to the Department of Motor Vehicles, change over the title of cars. They're going to be able to take this to the conveyance records in your parish and change over the title of different properties that are owned by the family. They're going to be able to access inaccessible access that might be frozen. Maybe you have not necessarily a retirement plan, maybe you have stocks and bonds. They're going to be able to use this judgment of possession to turn over these stocks and bonds. They're going to be able to use this judgment of possession to turn over assets at banks. And the major thing that's going to happen if you have a will is the succession is going to actually say whether or not the will is valid. And as we said before, actually who gets what and make that determination and put that whole thing in writing. So it is a process that can take a little bit of time. There are currently different strategies that people use to avoid probate. I'm not going to go into those today. That'll be a separate presentation. Maybe I'll touch on it a little bit. But that's just to demystify the process of succession and probate to everybody, to let you guys know what it is. Next slide, please. So we talked about the family before that owned the heirs property for, I guess we had maybe 4 or 5 generations of this family. And I've seen heirs property where it's still in the owner's name from the person who bought it in the 1800s. Like 1890, 1910, 1920. I've seen heirs property that's been titled to a person who's probably been dead for over 100 years or almost 100 years. I've encountered that multiple times. And one of the questions that people would ask is, well, why would a family not go through the succession, not have this cleared up? There are a few reasons. One of the major reasons that I've encountered is it's expensive for people to actually go through with the succession. There are other, expenditures that go with it. I've encountered that's starting to happen now as some families are starting to be hip to it, and maybe they're intentionally delaying going to succession because it's still in grandma's name and grandma has some sort of homestead exemption that they're afraid that they're going to lose. I will caution people that if you're in a situation like that, the state of Louisiana is becoming very good at discovering these situations where a family owns heirs property and they're receiving a homestead exemption it should no longer be valid. So it's definitely a dangerous thing to rely on. But definitely the expense of actually going to court and having a succession done is one reason. Too complicated. Eventually, when you get into a situation like we had where 75 years has passed since the original owners have died, it's going to involve a lot of people who need to be involved in the process of actually clearing the title. So it can become very complicated, even tracking down everyone, getting everyone's information, getting everybody notified. And like I said before, normally in that amount of time, it's many more people than 10 people. So it can be quite difficult. Limited access to attorneys. These are typically where heirs property is most prevalent, are typically in those areas where people did not historically have great access to the courts, historically have great access to attorneys. And there might even be not necessarily just a limited access to attorneys, limited trust in the attorneys, limited trust in the judicial system. And the biggest thing that we're dealing with right now is the idea that the longer it goes on, it becomes exponentially more difficult to clear up as time goes on. Because as you can see, we started off with one married couple, and then by the end we had 10 people, some of which have maybe never even met each other. Normally, we start off with one married couple, we end up with 70 people, some of which have never met each other, some of which have never even seen the property. So it becomes very difficult to clear these things up if they're allowed to go on for too many generations. I touched on this earlier, historic disenfranchisement and distrust of institutions. This is a very important one for me in that at one point in certain families, in certain demographics, let's say everyone did not have the same access to courts. If you were Asian, you were Latino, you were African American, in the 50s, 60s, we did not all have the same access to courts. We did not all enjoy the same due process and protection under the law at different points in the history of the United States. The reason why certain families did this was not necessarily out of ignorance. It was an actual strategy that certain families used to protect their property. Their idea was, if I can keep this property out of the newspaper, out of the courthouse records, it'll be less likely that someone will come and try and dispossess us of the property. It was a valid strategy for a very long time and people did use it. It was not completely out of ignorance. However, things have changed. Now we're doing the Zoom chat. I'm sitting in New Orleans. Most of you guys are somewhere in Louisiana. Some of you folks are probably not in Louisiana. We do everything over computers now. We can communicate across the world instantaneously. What else can be communicated across the world instantaneously? Our property records. They're all on computers that can all be accessed, and it is a great thing that we have this ability to do this. But the idea of I'm going to protect my property by keeping it out of the newspaper, by keeping it out of the court records, none of that matters when we can all look it up from our computer now. None of that matters anymore. So it's no longer, in my opinion, no longer a valid strategy or a strategy that you can rely on to protect your property is through not clearing up the title records. Now I think most people should definitely consider this. Can I get next slide, please? What are some of the challenges to owning heirs property? What are reasons why you might not want to own property like this? One, it is an unstable form of property ownership. And what do we mean by unstable? What I mean when I say unstable is there are a lot of opportunities for you to end up, for the family to end up losing the property. We have the idea of acquisitive prescription against co-owners and in division. That doesn't really happen. Let's not worry about that. We're going to talk about that a little bit later. What normally happens, how families normally lose their heirs property is sheriff sale or tax sale. Let's say in New Orleans or another area that might have had recent natural disasters, maybe the property is in disrepair, the lawn's not being mowed, and it's gaining fines from the municipality, from the city, from the parish. It's gaining fines, and then eventually the property goes up to auction because of that. A lot of times when a bunch of people own a piece of property and no one's really enjoying it, it's difficult to convince any one person or any group of people to actually pay the property taxes on it. That's another way that you can lose it. You can lose it through tax sale. A common thing that's starting to become more and more common way that people lose their property is through a third-party interloper. And what happens with that is, if you remember that scenario we had the one family member who lived on the property, and then we had multiple family members who had, as they got further and further apart, who had less and less relationship to the property. What I mean by a third-party interloper is the idea that someone could buy out your relatives who have no relationship to the property, can buy them out, and then a third party can force the family to partition sell, where this third party knows that they're going to be the party with the best likelihood of actually winning the property in a partition sale. It actually does happen to families. At first, at least me personally, at first I thought that this was more of a thing that happened to rural properties. Maybe the property has some timber on it. I've seen that before, but it's increasingly, I'm starting to see it actually in urban context with just single family homes. We have this idea of gentrification. Some properties, maybe your family bought this property in 1970 for $40,000, and now the property is worth $1 million. Yes, it is starting to happen even in Louisiana. It's actually a huge issue on the East Coast with this type of thing. And yeah, another way that the property might be lost is the idea of a family buyout, which is not necessarily the worst thing, family buying themselves out, but the actual tension that it could cause in the family with who actually has the right to own this property, who actually has the right to enjoy this property. A common thing that we see is the family's in agreement that the relative who owned the house believed that this person should get the house. However, they did not have a will. They did not go through the formalities of transferring the property to this relative. And now it is a family issue over who actually gets the house. So yeah, we would like to avoid this at all costs, avoid family strife. Next slide, please. So not only are there the issues that we just talked about, some of the common issues that we had, that Louisiana Appleseed was actually founded on dealing with, was in the aftermath of Hurricane Katrina. There were people whose homes were damaged, and maybe they own this property as theirs property, or maybe even, sadly, unfortunately, their relatives may have died in the storm and they inherited this property. So one of the issues that we had that's since been mitigated to some degree was actually receiving payments to repair the property from the federal government, from the state government. If the municipality, if the parish says Grandma Reynolds owns the property and Grandma Reynolds been dead for 30 years, at one point it was very difficult for me to actually get FEMA to cash me a check for this. FEMA has since relaxed a lot of their requirements. At one point it was very difficult for me to get the state of Louisiana to give me this relief check. Even then, once receiving the money from the federal government or the state government, there's still the issue of, can I cash this insurance check in my name, even though the property was in this other person's name, or even convincing contractors to work on the house. These are all issues that people have encountered owning property like this, not being able to receive disaster relief and not being able to repair their homes, not being able to receive insurance funds, and even negotiating with banks to receive mortgages that you might need to repair your home. So there are a lot of issues that can come up when you own property like this that you don't foresee. It might not come up every year. It might come up every 10 years, but it is an issue that is on the forefront of one of the reasons why, if you own property like this, you should look into solidifying, consolidating ownership, and having the title be clear so that you can avoid a lot of these issues. Next slide, please. Not only does heirs property have issues for the individual owners, it's also potentially an issue to the communities where heirs property exists at. One of the major things that heirs property does, I live in the 9th Ward of New Orleans. I'm in the 9th Ward of New Orleans right now, upper 9th Ward. I live on a block where before Katrina, there were maybe 40 single family houses on the block, maybe 40. Katrina's been, good Google the movie, Katrina's been 20 years now. On this block that I live at now, 20 years later, we probably have 20 of the 40 houses back. If I were to look at those 20 houses that are still in disrepair, they're not all in disrepair. They're not all in disrepair. But of the ones that are in disrepair, and even the ones that are in repair that just no one lives in, I would bet my savings account that most of those happen to be heirs property. That most of those are in a situation where multiple people own them and no one really is in the situation or is incentivized to take the lead on rehabilitating that property and putting that property back into commerce. So it's also a community issue where it can leave property out of commerce And a lot of times when property's out of commerce, not necessarily, but this property can become blight. It can decrease the property value throughout the community. It could be a health hazard throughout the community. It could also be an actual physical safety hazard throughout the community. So not only are individuals encouraged to avoid owning property in this manner if they can help it, but it's also advantageous to the communities where property is to not have an abundance of property that's owned like this. Not to say that all heirs property is in disrepair or even behind on its taxes. There are plenty of people who manage to keep their property in repair and their taxes paid, but it is still an issue of the property not being in commerce with a lot of families. So just definitely things to, if you're not going to tackle these issues for your relatives, for your descendants, maybe consider tackling these issues for your community. Next slide, please. We talked about loss of heirs property and the idea of a third-party interloper and a partition. This is the code article in Louisiana. No one may be compelled to hold a thing in division with another unless the contrary has been provided by law or juridical act. Any co-owner has a right to demand partition of a thing held in division. Partition may be excluded by agreement for up to 15 years or for as other such period provided by specific law. The main reason I show you guys this is whenever you own property in division with co-owners, let's say we're not talking about community property. We're not talking about community property. We're talking about heirs property that you might have inherited where now you and your siblings or you and your siblings and a bunch of your cousins all own this property together. Any one of those people can trigger a partition sale. They're not forced to own this property with you anymore. There are different laws that are coming up. We're going to talk about them that are potentially coming to Louisiana that are going to sort of make this a less of an issue. But for the current standpoint, it's going to be a thing that you have to consider, that one of your relatives or a group of your relatives could force this property to partition sell, and the whole family could end up losing it. One of the biggest issues with the thing going to partition sell, one, obviously, if we want to keep the property, it's very bad for us to lose the property. That's somewhat obvious. But even compiled with that is the idea of a property that's sold in this manner. Not only will we lose the property, we're going to lose the property for most likely below market value, most likely far below market value. So not only are we losing it, we're not even getting what we think we deserve to get for it in turn. So it's definitely something that we should be cognizant of if we own a piece of property with a bunch of our relatives and we're not all in agreement and we don't have a plan to consolidate ownership or clear our title into one entity. We'll go into the entity issue later. So just to let you know that is an option that families have, is to force partition, and it is there because we have this law where people cannot be compelled to be co-owners with someone else. Next slide, please. There are two types of partition. The general partition would be partition in kind. That's what we think of when we normally think of partition. Let's look at this image on the right. As you can see, we can see like the different shades of grass. That's normally an instant indicator if you're looking at overhead aerials of rural property, of where the actual property lines are. And you might actually see the little roads dividing them, and that would be where the old property lines were normally. That's how I could look at that and tell you that. And so what happens is maybe somebody owns a piece of property like we have in this square, this green square on the side. A square like this, as we can see, it could be partitioned in kind. There's a way to cut even blocks out of this, right? Let's say if 5 people own this, there's a way to cut this property into 5 pieces. Or at least there's an argument that there's a way to cut this property into 5 pieces. By the law, Louisiana, we prefer this kind of partition. In practice, this is not necessary. This is not normally what happens. And I'll get into that a little bit. What normally happens is we have a partition by licitation. That is partition by sale. That is when the whole property is put up by auction, and then whatever amount of money comes back, the co-owners split that amount of money. And for the most part, if we look at like the image we have on the left, a house, it's sort of obvious how we could split up. I guess that's maybe 80 acres, I don't know how many acres that is. On the right, let's say that's 80 acres. It's sort of obvious in most instances how we can split up 80 acres amongst 5 people. It's like, oh, this person gets this 20 acres, this person gets that 20 acres, this person gets whatever, math. It's less obvious how we could split up a house amongst 5 people. Drastically less obvious. Some would say it's impossible to split up a house amongst 5 people if you were to partition it. You're not going to go, oh, he gets the living room, he gets the attic. We're not going to do that. For the most part, that's not feasible for 90% of residential properties. It's not feasible. And that's when the idea of partition by licitation, if you have a co-owner, a relative who doesn't want to own the property with you, that's where it gets put up for sale and all the money is split. And so we talked about the issue of the third party interloper a few slides ago. That's what could happen. And that's actually the strategy that certain developers are starting to use now. They find habitual pieces of heirs property that might be very difficult for the family to clean up in a hurry, might be expensive for the family to clean up in a hurry. They buy out the requisite number of co-owners, of heirs, and then they force a partition sale, knowing that in that amount of time, the family won't be able to raise that amount of money to actually match the developer. This is starting to happen. The prevalence of this is where a lot of the arguments come in, is how often does this happen? I think it happens a lot more often than some people would like to admit that it happens. But it's no longer just a rural issue. It's also starting to happen in urban areas also. So those are the 2 types of partition, and just reminding people that although you might have acres and partition in kind is the preferred method of partition, lots of judges are just going to lean on partition by sale just automatically. So if you want to keep your property and not just have, pennies on the dollar returned to you for your property, definitely consider clearing up the title. Or if you're the owner of a piece of property like this, definitely consider some method of passing clear title onto your heirs who you want to own who you want to be owners of the property, to avoid losing their property in this method. Next slide, please. Tax sale. Yeah, we talked about this enough, but I'd just like to point out that the normal way that things end up in tax sale is when you have so many owners. Some people would say if 10 people own a house, nobody owns a house. I've heard that expression said before. I'm somewhat in agreement with it, but I do know of families where no one's lived in a house. They've been paying the taxes for 20, 30 years. I've encountered that many a times, but that's not necessarily something you could rely on indefinitely, because what happens when your uncle becomes your great uncle, becomes your great great uncle, and now he's deceased? Normally it's 1 or 2 people in the family who's taking care of this, where they're the ones who are upkeeping the taxes while the family's on a clock trying to figure out what are we going to do with this property. And then eventually 20 years, 30 years, 40 years, that person's going to pass eventually. So I don't necessarily think that you can rely on this method indefinitely without actually coming up with some sort of plan on what we're going to do with the property. Yeah, so it's definitely a dangerous game. We talked about the homestead exemption. That's another thing that I've seen happen, where families are still using the homestead exemption from someone who owned a property who's been deceased for 20, 30 years, or even more recently, 4 or 5 years. Eventually, something could happen where you're going to have to go in and get something done to that property, where you no longer have this homestead exemption, where it becomes apparent that you can't rely on this. I've seen instances where families have lost their homestead exemption and had the actual, what the assessor says the taxes should have been for the last 3 years, where they bumped those taxes up to the rate it would have been without a homestead exemption. And now, instead of looking at 1 year of paying the rate that the assessor says should be without the homestead exemption, you're paying 3 years of this. And for a lot of people, an unexpected $500 tax bill is too much. And for, I would say, pretty much all of us, an unexpected $5,000 tax bill is too much. It's something that we can't really account for. So one thing that I'd like to recommend is we try to avoid owning our property in situations like this, and being proactive about clearing up these issues before they come. Next slide, please. One of the new things that's on the horizon, this is a map of the UPHPA, Uniform Partition of Heirs Property Act. This is a map of the states. I believe this is still current. This is a map of, at least it's current for our area for sure, a map of all of the states that have passed the UPHPA. I'm going to go into some of the protections that the UPHPA will have if we were able to get it passed in the state of Louisiana. As you can see, our neighbors Texas, our neighbors Mississippi, Texas, Mississippi, Arkansas, Alabama, Florida, they've all passed variations of this model legislation that's specifically aimed at helping heirs not lose their property in the various different ways we talked about they could lose their property. Specifically, the major thing that this is protecting folks from is the third party interloper that we spoke about earlier. Can I get the next slide, please? Oh, I'm sorry, this is so small. So the Uniform Partition of Heirs Property Act, it's going to give a bunch of different protections, but the major thing that I'd like to look at right now is the right of first refusal. Those instances where, like we showed our family tree earlier, where you have one relative who lives in the property, pays taxes on the property, a bunch of other relatives who are more remote but have some relationship with the property. It is an instance where maybe one of your relatives, for whatever reason, they don't want to own the property anymore. They don't, and there are a lot of valid reasons why your relative might not want to own property, right? Lots of reasons. They don't, and what this would do is, instead of them selling it to a third party without notifying you, this right of first refusal would mean they would give you an opportunity to actually match whatever this third party was going to offer them. So they still get their money and they're still out of the property, but the property is still it's still in the family, still consolidated amongst the relatives. So that's the major thing that I wanted to point out about that. That's a protection that would come from us adopting the UPHPA. I'm not sure how close we are right now, but it's definitely on the table. There are definitely talks about it going in front of the legislature. Next slide, please. Okay, I'm going to actually go through all these. Here are the 5 pillars of the UPHPA. And enhanced notice provisions, including notice by posting if notice by publication is requested. Independent appraisal of property, assuming sole ownership of the fee simple estate. So buyout provision, we talked about the buyout provision. Partition preference. This is a big one that we talked about earlier. The idea that in theory and law in Louisiana, we have a preference for partition in kind, but in practice, we have a preference for partition and sell. What this would do is this would codify in law the actual recodify, I guess you'd have to say, that we're going to have a preference for partition in kind, which would mean even if you were forced to partition, you don't lose the property. You lose that portion of the property relative to the percentage that your relative owned. And then also open market preference. So the biggest thing about all these is, 1, protecting people from losing property. 2, if the family loses property, they don't lose it for a below market rate, they lose it for a market rate. 3, the preference for partition in kind, maybe you lose a portion of the property, not all of the property. And open market preference, like we said, protecting people where they don't lose the property for below market rate. There is a question, is the UPHPA compatible with Louisiana law? I would say that question's pretty much been put to sleep over the last few years. A lot of lawyers and politicians way smarter than me have been having this conversation for the last 5 years. And I think for the most part, folks have settled and agreed that there are ways to make the UPHPA compatible with Louisiana law. Next slide, please. I think we went through this pretty good. I'm not going to go through that. Next slide, please. We went through that already. I spent a lot of time on that. So I guess the reason why, okay, let's go back to the last slide. I understand why I have that now. Different ways that people can actually clear up their heirs property. And we're going to make a little bit of we're going to distinguish between heirs property where it's maybe you own a bunch of acres and maybe it's farmland, maybe it's timberland, maybe it's some sort of piece of property that's amenable to divisions. Maybe a bunch of your family members have trailers on this property, something like that. In these instances, one way that we can resolve it, and this is how they did it in the old days, is they would actually subdivide the land. This person gets this acre from this acre. This person gets this acre from this acre, from the lake to the river, whatever, things like that. This is an option that people have with parcels of land that are amenable to it. A lot of times what we'll see now is maybe it's a piece of land that's large enough where it would have been amenable to that, but now it's been going on for so long that we have 70 or 80 people involved in it, and it's probably also still no longer amenable to that. What happens when you actually go through a legal partition of the land is, right now, if me, you, and everybody who's in this conference, if we all own a piece of property in division, it doesn't mean that I own this corner over here, you own that corner over there. It means that each one of us owns a certain percentage of every molecule of dirt and air on that land. Every blade of grass, we each own our relative percentage of every molecule on the land. What a partition would do is it would consolidate different people's ownership into different subsections of the land, into different squares or blocks, or however you want to come out, pieces of the land. And so once that partition actually goes through, this east half over here, I no longer own a portion of that. I just own a portion of what I'm left with. And so a partition is a decent way to end collective ownership of a large piece of land. Obviously, we talked about it earlier, not necessarily the best thing what you want to see happen if you own a house or even other sorts of type, or for whatever reason, maybe it's a hunting ground that you don't want to partition a hunting ground. Maybe you want to have it where we're all capable of hunting on it the whole time, and which is a valid thing that a lot of families might desire. Next slide, please. Well, and I'm not going to limit this to limited liability company, but then there's the idea of owning this property in some sort of business entity, right? A lot of families have started to do this, where it's a business entity that owns it, or maybe it's a trust, maybe it's an LLC, maybe it's a corporation that owns this property and administers this property, where there's some sort of agreement on how the family is going to administer the property, take care of the property, things like that. And one of the ways to do it is an LLC. LLC is going to have a lot of different requirements to make sure the LLC is still active. Yeah. And so this is definitely an option. It's sort of a more, I don't want to say more sophisticated option, but I've normally seen it in instances where people have timber rights or mineral rights on the property. It's actually quite common in those instances. Even with the limited liability LLC route, one of the things I like about it is, let's say you're in an instance where it's 90 people who own this property together. If you're going to go the LLC route, you don't necessarily need to get all 90 people to agree to be in the LLC. What some people do is they slowly but surely, they increase the consolidation of the property, where they get those people who will agree to be in the LLC to all put their interest in the LLC. And then it makes it a lot easier for them to negotiate everything else. And then as new people come up along, they just gather them into the LLC also. So that is a strategy I've seen families go through to, throughout the course of time, consolidate ownership of the property in one entity. One reason that I would like to point out why this is definitely advantageous to having multiple, unclear title, or even multiple individuals own the property. Should some timber company, should some mineral company, should some property developer want to come and purchase the property from you, it's an entirely different negotiation when it's one entity speaking versus 90 separate entities. It's a completely different negotiation. It puts you in a much more advantageous position, one, for you guys to protect yourselves, and two, for you guys to get the best deal possible. Next slide, please. Family land trust. This is actually a very up-and-coming device that people are using, where the family owns the property in trust. Yeah, this is definitely a good one. It accomplishes a lot of the same things as the LLC, but it's going to have slightly less formalities and also slightly less protections too. But there are ways to write up these trusts where they're taking care of the family, the ownership is consolidated, and it is protected from outside parties. These are definitely things that we should all consider. I'm just trying to get through one time. Okay, next slide, please. Sorry. Not going to go into this. We went through this very quickly. All this slide is letting you guys know the idea of adversely possessing against your co-owners, your relatives. It is functionally, it's very difficult to do. I'm not going to say it's impossible. It is very difficult to do, and I have never seen it be successful per se. I'm sure it's happened for someone, but the general idea, things that you would do to adversely possess against a person who's not a co-owner with you are not going to work against your co-owner. This idea of, I'm going to put up a fence. Putting up a fence, unless you explicitly lock your co-owner out, is not actually seen as adverse possession against your co-owner. I'm going to mow the lawn. I'm going to pay the taxes. I'm going to take care of this property. I'm going to lease this property out to someone. All these things you're doing when you're co-owners with somebody, it's presumed that you're doing it on behalf of your other co-owners. So really the only reason why this slide is here is to let you know it's actually very difficult to adversely possess against a co-owner in Louisiana. I think it's pretty difficult in most places, but there's a reason why. One of the things that you do have, money that you put into the ownership, whether it be taxes, whether it be upkeep of the necessary upkeep of the property. These are monies that you can get back from your co-owners that you are owed, that you can go through legal process to recoup from your owners, or should you guys decide to sell, you could recoup from them. So you do have some protections if you are the relative who's paying the taxes. I recommend that you keep pretty good records of that. And yeah, if you are the person taking care of the property, maintaining it, there are instances where you can recoup the necessary maintainment of the property where you can recoup these things from your co-owners. Next slide, please. One of the more complicated things that we don't really touch on a lot when we talk about heirs property is what does it actually take to clear out heirs property in an instance where you have 90 people. The first thing is figuring out who all the owners of the property are. The first step that anyone's ever going to do to solve one of these is going to the assessor's office or the assessor's website and seeing who does the assessor believes own this property. Who does my parish believe owns this property? Who is that individual or set of individuals? And then you can start from there. Typically, when you look at an assessor document, whether it be the website or the actual physical cards in the assessor's office, there are going to be some annotations on it. And these annotations are going to lead you to books and pages in the parish conveyance records. And these books and pages are going to be conveyance records of where the assessor believes your family came into this property, right? And so one of these is going to be the deed that maybe your parents or your grandparents got the house under, or some other sort of mechanism where your parents or grandparents or even great grandparents got this property. So title clearance is going to start with the assessors. Then we're going to be in the county, the parish clerk of property records division, and we're going to actually be doing what's called building a chain of title. We're going to take those documents we saw from the assessor's office, and we're going to follow those documents to every other transfer involving those people, involving that piece of property, to see who else's names come up related to that property, right? In some instances, maybe no one's name comes up. Sometimes the only document will be that last transfer in 1935. Sometimes that's it. Then we go into other records. We go into newspaper records to see this person's obituary, the owner of record to see their obituary. Did this person have children? And then that's when we start building the family tree. Did this person have children? Now we're going to try and find this person's obituary. Did this person have children? Then we're going to look in the parish records of marriages, divorces, child support, things like that. We're going to build the family tree out from there. It can be very arduous depending on how long ago it was, but it is a thing that's possible. Another thing we're going to do is we're going to look at archival newspapers. Maybe somebody graduated, maybe somebody wrote a book and it comes up in a newspaper. Archival phone books, that's actually my favorite. Very useful. In most parishes, you can find phone books going back 60, 70, not 60, 70 years, 40, 50 years. I've used that pretty good. There's even a website, a great website, findagrave.com, in conjunction with obituaries, where a lot of times you can find the person's grave. Certain families are buried in the same graveyard, and you can find other relatives in that same graveyard on findagrave.com. I guess, and lastly, one of the more not necessarily available to rank and file people at a higher level once you start hiring like firms and things like that to do the title clearance, is the idea of skip trace. That's pretty much how creditors find you, but it also works for finding missing heirs. Skip trace is basically a computer software program, I guess you'd call it. I don't know what to call it. Network. I don't know what to call it. Where you can put in someone's name, social security, who they're related to, and it'll show you. It'll guess their addresses for you, guess their phone numbers for you. Not guess, but it'll go through their database. And so there are some very sophisticated tools that can be used to clear heirs property. But one thing we can all do is we can start our family tree, right? We can start it from just the people we know. And then maybe when we go to a family reunion, maybe there's someone else in a different branch of our family who's also done it. And having information like that is going to be invaluable to generations going forward. Next slide, please. Burial directions. I'm not going to go into that. Next slide, please. Don't have time. So this is seemingly one of the less important things, but I'm starting to realize it's one of the more important things because it's a question I commonly get. Let's say you've gotten the will done, you've gotten all your deeds together, you've done your other end-of-life documents, and you have all this stuff, and people ask, where should I store these documents? I actually do not know the best place for any individual to store their documents, but I will go through the common places I've heard people say that they store their documents and the pros and cons of those. I will say, just for starters, online storage is not good for your will. That's not a good place to store your will. We have to make the differentiation between a duplicate of your will and a copy of your will. Your will is the actual sheet of paper that you either, if it's an holographic will that you completely hand wrote yourself, signed and dated each page yourself, that's your will. A photocopy of that is not your will. That's something different. It has some use. It has some, I guess they'd say, probative value. Should you lose your will or your will become destroyed, not by your own efforts, it might be of some use, but it's not the same as your actual will, right? So an online storage, if that's the only place you have your will, that's not a good place to save your will. You're going to need to actually safekeep that actual physical document to get its best use. That's what your family's going to need. Keep will in a secure place at home. That's cool. You can keep it in a safe at your house. You can keep it anywhere. And, I just recommend that if you keep it in a safe, that someone besides yourself knows how to get into the safe, because should you pass, they're not going to know how to get into the safe. And this goes for all of these. Having someone, a trusted person, if you have a trusted person, maybe it might be your executor, maybe it might be one of your beneficiaries, maybe it might be your best friend, that they know that you have these documents and that they know where to find these documents. Store your will with an attorney. That's an option, sort of old school option, but I believe it still exists. It does beg the question of, maybe the attorney is a safer place for me to keep my will. What happens if your attorney dies, retires, gets disbarred? What if there's a natural disaster where your attorney also has to evacuate? You're only going to have as much access to that document as you have access to your attorney. Filing conveyance records. I've seen that normally for people who have a lot of timber rights. You can file it in conveyance records, but it's going to be very difficult. It's going to be expensive, one, to file it in conveyance records. Two, it's going to be difficult if you change your mind to change your mind, where you have to also file that into conveyance records. I don't necessarily recommend this for a lot of people, but there are people who know exactly how they want things to go, and that is a route that they take. Safe deposit box, let's say it's at a bank. It's going to be a similar issue with an attorney. You only have as much access to that safety deposit box as you have access to the bank. We had instances in Hurricane Katrina where the banks closed. Now you can't get to these documents. We had instances, maybe not so much in Louisiana, but Mississippi, where the bank is literally not there anymore. The bank is no longer standing. It's wiped away. So I'm not going to say you should not keep your important documents in a safety deposit box, but saying that there are pros and cons to each one of these. Let's lump in executor or beneficiary with trusted person. Yes, if you keep it with a trusted person and they keep it at their home, maybe that limits your family's ability to snoop on it, but it also increases whoever has access to their house ability to snoop on it. Maybe they'll have less interest in it at their houses, but there are pros and cons to all of this. And like everything else, you only have as much access to the documents as you have access to them. So if you leave it with someone else, your family should also be notified, here's who's going to have this. A common one that I got a lot, and I kind of put it in there as a joke, but I've heard it enough, in the freezer. In the freezer. I get that a lot, and I get that is an old school way of saving things. And if that's where your family knows where to find it, if that's where you feel with it being secure, I don't necessarily feel with it being secure there. But if you do feel like that, I say as long as you keep it in stuff that keeps it protected from the elements, if that's the best place you can think to keep it, I'm not going to tell you not to keep it there. I'm pretty sure that's where my grandmother keeps all her stuff. So yeah, I keep my stuff on. I live alone. I keep my stuff on my desk in a bag labeled important documents. So please don't rob me or anything like that. But yeah, and so that's what I got on Heirs property for you guys. Sorry that I took so long. I should have went through a lot of that faster. But here we are, snow day. I can't believe we're having a snow day in Louisiana.
Yeah, it looks like we have some time for questions. Um, okay, thank you. Let me just check the Q&A. Okay, we have a question.
Uh-oh.
Do beneficiaries of a trust pay inheritance taxes?
Oh, I am not sure. I don't do trust. I will say that there are ways to, maybe you can answer this one for me, but there are ways to format trust where you limit the amount of inheritance taxes people pay. Most of the folks I've been dealing with recently have been in an instance where inheritance taxes weren't necessarily that big of a concern. But if they are concerned, we're trying to develop a program specifically dealing with trust because I'm starting to see that that's what the people want to hear about. Maybe if you check in again with me 6 months from now, I'll be doing one on trust, or we'll have someone else on Law Talks doing one on trust.
Okay. Let's see. Another question. Will I still need a will about my property if I have a special needs trust?
The simple answer is yes. Most people will still need a will even if their property is in trust. You're still going to have a will. I guess I'm trying to give the exact term for the will. So when you have a trust, you have to make sure your trust is funded. You have to make sure that everything that you own, as you own these things, they're going into the trust. You're still going to have a will to catch those things that you might have mistakenly not added to the trust, or for whatever reason, maybe you gathered these are things that you came into ownership with in a way that they missed your trust. So you're still going to have your will as a backstop. It's not going to do as much heavy lifting as the things that go into your trust. And when we say a special needs trust, let me think about this, because that's a very specific type of trust. When you say if you're the beneficiary of a special needs trust,
It says, will I still need a will about my property if I have a special needs trust?
so I'm going to assume that this is a person who's not the beneficiary of the special needs trust, a person who's writing a special needs trust to go to one of their relatives. I'm going to say you're still going to end up with a will. If you have the special needs trust written, I assume that the lawyer who wrote your special needs trust would also include a will. I would assume that, but I'm not certain about that. But I personally would assume that. If you're the person who's the beneficiary of the special needs trust, that's a different sort of conversation. And I would say that one's, I've never dealt with the beneficiary aspect of a special needs trust.
Okay. We have a couple more, Jonathan. The next one, will verbal wills recorded be accepted?
I'm going to say no. I'm going to say in Louisiana, let's say verbal wills recorded. We talked about earlier that people who are illiterate, people who do not speak English, people who are blind, people who can't speak at all can all have wills in the state of Louisiana. And we have formalities for all of these things. It's going to be a little bit more difficult for your lawyer, for your notary to follow the formalities of these things. But one thing that we have to remember in Louisiana, as far as we go with successions and wills, we have one of the strictest formalities of will formats in the world on what happens if you don't follow this format. And to my knowledge, I don't believe that we have a formality. We have one for what do you call it, video wills. I imagine your video will could be something that could be used in conjunction with a testamentary will to help that in some kind of way or another. But the gold standard in Louisiana is going to be either a testamentary will or a holographic will. I don't know the case law on if a video will could be a testamentary will, but I would not rely on anyone who's sophisticated enough to get a video will. It's definitely not going to pass as an holographic will. I can just tell you that right now. It's not going to happen. But anyone who's sophisticated enough to have a notary and attorney do a video will, I think you're also going to have the wherewithal to actually go through the process of having it written up also. Yeah. So I would not rely on, especially if it's just a will you recorded yourself. I would not feel confident that that would be relied upon.
Let's see, another question. Is it possible to make requests for who gets certain property?
If you're the person writing the will, you can leave, for the most part, you can leave your will, you can leave your property to whoever you want to leave it to. There's also the issue of forced heirs, forced heirship. If you have forced heirs, or if you have maybe a spouse and you are drastically more wealthy than your spouse, it's virtually impossible to write a forced heir out of the will. There's very limited circumstances. A forced heir is going to typically be an heir who's under the age of 18 or an heir over a certain age who experienced some sort of disability before they were, some sort of permanent disability before they were 18. It's virtually impossible to write a forced heir out of the will. There are some very specific circumstances with which you can do that. And then there's also the issue of marital portion that comes up sometimes. But for the most part, if you're writing the will and it's your property, you can leave it to who you want to leave it to. Right?
Great. Two more. So it says, what are other options when parties don't agree before initiating a partition sale? Do you have a list of attorneys who handle partition sales?
No, I do not. I've been in the process of trying to gather up a list to refer people to specifically for dealing with heirs property. I don't have a firm list of yet. Also working with Southern University Law School, we're trying to develop some curriculum to train lawyers up on these things. So I do not have a set list of referrals right now. My primary referral is for elderly people or people who might be of low income in Orleans area, Southeast Louisiana Legal Services, outside of Orleans Parish area, Acadiana Legal Services, still in Louisiana. They're definitely more than capable of dealing with folks who might happen to be elderly or low income with these issues and counseling you through these things. But I will say a lot of times when we get into an heirs property issue like this, even when it's as few as 4 or 5 people, one person not agreeing can make the whole process so much more difficult. Trying to figure out some sort of mediation type issues, but I don't know if there's ever going to be a day where a handful of people not participating won't make it a headache. I don't know what the actual option is around that, and I can feel the frustration of this question through the screen because I've seen it happen a million times where we have 10 people in agreement and one person not, and it slows everything down. So I wish that I did, but I'm working on it. So definitely keep up with Louisiana Bar Association. Once we get things like this up and running, that's gonna be the first people we're gonna tell and let them promote it. Yeah.
Okay. Last question. What is a trust, and is it possible to set up one for grandchildren who are minors?
Yeah. What is a trust? A trust is gonna be an entity where I no longer own the property, the trust owns the property. And instead of the beneficiaries owning the property, the trust owns the property. And so it's normally used, I think we've had the word special needs trust. We've also talked about inheritance tax. It's normally used to protect the beneficiaries from either one, squandering or destroying the property where they don't have an actual right to the property per se. They have a right to the money that comes from the property, or they have a right to enjoy the property, but they don't necessarily themselves own it, right? The trust owns it, right? What was it? So that would be the case, special needs. Or the idea of, what do you call it, inheritance tax. Or a lot of times people have it, special needs trust, where it's trying to protect their beneficiaries from some people, certain government programs. If you own too much property, you're not eligible for the program. So a lot of times people might own something as a special needs trust like that, where it's like, I own the property, I guess, but I really just own use of the property and the ability to the fruits of the property, but I don't actually have the ability to dispose of the property myself. It is possible to set things up like this, to my knowledge, for children. That's a common way that it's used, but definitely slightly beyond the scope of what I'm here for today. but I'm sure someone else will come back with trust if it's not me in 6 months. If it's me in 6 months, I'll have that already for you. Or if it's someone else, I'll log in and we'll all be there asking questions. It'll be great.
Okay. Let me just reshare my screen a minute and do some just wrap up, um, if that works. Give me 1 second. Screen. So thank you, Jonathan, for answering those questions. But real quick, if you need any additional legal assistance or information about this topic or other civil legal issues, please check out the Civil Legal Navigator, which you can find on our Find Legal Help page on the LSBA's homepage. It will help you diagnose your issue and provide customized referrals and information. Please also check out our legal help access points to get assistance with your civil legal issues. These access points are physical computers or booths that allow users to access a spectrum of services and information, get customized legal information and referrals, see if you qualify for legal aid, schedule meetings with a legal aid attorney, and attend virtual court in participating jurisdictions. Access points are currently in libraries in Lake Providence, Faraday, and DeRidder. One is in the LaSalle Community Action Association in Harrisonburg, and we just opened one in the St. Bernard Complex in Chalmette. Please mark your calendar for the next law talk. It is scheduled to be on February 13th at noon, and it will be on workers' rights. Thank you so much, Jonathan, for joining us today and presenting on this really very important topic and providing such useful information. We really appreciate it.
Thank
Thank
you
y'all.
guys.